Hi everyone, welcome back to another episode of Providence Money Wisdom Podcast. I'm your host, Isaac, Associate Advisor at Provident. So to all our listeners, I would like to thank you for your support and really tuning in to listen to all our episodes. So for today's episode is a bit content heavy and the topic will be estate planning. So today our guest is Eddy Cheong, who is the head of our solutions team. So what we will be going through will be the three main aspects of estate planning, namely distribution, creation, and estate preservation. So after we have gone through all these three main aspects, we will be doing a summary of estate planning. So without further ado, let's jump right into the episode. Hi Eddy.
Hi Isaac, thanks for inviting me.
Thanks for taking the time to come here today, Eddy. So before we begin, Eddy, could you give a quick introduction about yourself?
Sure. A brief history of myself. I started my career as an accountant for 5 years, and after that, I moved into the financial industry for the next 25 years. I've been with Providence since it started, so I've been working here happily for the past 2 decades already.
Wow.
Yeah.
Okay, so the solutions team scope of work is very big. You know, it encompasses a lot of things. So who better than you to let our listeners know what the solutions team role is in Provident? So could you just briefly describe what the role of the solutions team is?
Okay, sure. Basically at Provident, we organize ourselves in team-based approach. Right, we have the advisors team, we have the solutions team. So the advisor's main job is basically to provide the best advice and managing the client's relationships. The R&D that goes into the advice is basically the job of the solutions team. So let me give an example. If we have this proprietary retirement system called the Retire Well, and this system is architected by the solutions team. It took us about 2 years from conceptualizing R&D and finally rolling this out. But our job really doesn't end there. You know, as a solutions team, we're always looking at ways to enhance and make it even more robust. We also develop other financial planning frameworks, for example, for insurance planning, for estate and legacy planning, and planning for accumulators.
Right, so in a way, the solutions team is like the brain behind the advice.
In a way, yes. We are constantly looking at how to make complex things simpler, executable, and repeatable.
Right, thanks for sharing, Eddy. So this week's episode is about estate planning. So as you know, this topic is very important when it comes to financial planning, but it's often overlooked. So to begin, could you define what estate planning is?
Sure. We all own things while we are alive, like money, investments, properties, and all these financial assets. These are called assets while we are alive. But the moment we die, these financial assets will be given a new name. It's called the estate. So estate planning is simply means having a plan to transfer the deceased estate to their loved ones without unnecessary delay and avoiding any unexpected situations that may complicate the entire distribution process. So in a nutshell, a good estate plan will need to address 3 key parts: estate creation, estate preservation, and estate distribution. Maybe let me describe a little bit high level of these 3 parts. For estate creation, it's necessary when the size of the estate is not big enough for the beneficiaries. Example, if you want to leave behind $3 million for your family members in the event of death, but you only have $2 million. So in this case, you need to have a plan to create your estate by $1 million. So for estate preservation, basically it means looking at ways to prevent your estate from shrinking due to leakages. So back to the example, your $2 million estate, right, might suffer reduction due to certain expenses incurred at death or liabilities in the event of death, right? Such leakages can potentially be significant, and you really want to preserve your estate from eroding. Lastly, estate distribution. Basically, it means to ensure that estate is distributed to your intended beneficiaries and not to anybody else. So in GIS, estate planning will involve these 3 parts of estate creation, preservation, and distribution.
Right, thanks for giving a high-level view over what estate planning is. you mentioned many points just now, but could you elaborate why estate planning is important?
Okay. There are many reasons why it's important, but I just want to bring up three the big ones. I think these are the big ones. And firstly, it concerns on hard-earned money, and we really want to go to the right person and not to people that we don't want to inherit all our hard-earned money. Number two, we don't want to leave behind a financial mess for our family members to pick up. And that could happen when we don't plan our estate well. So let me give an example. It's common for people to have money in many places. They put their money in the banks, investment platforms, and even investment robos that you can open so easily. All right. So if you are the secretive sort, you don't want to tell people about your money. Okay, how do you expect your family members to know where your money is when death occurs? You see, you can imagine it's a messy process and it will require a lot of time and effort to sort it out. And lastly, the third one I will give is that we want to avoid any family disputes or disharmony because of any unfairness in the distribution. And this can happen because the deceased intention is not clear as it's not spelled out in a will. So in order to avoid or minimize all these complications, it's important to do estate planning well.
Right. So as estate planning is really a huge topic. Today we will be focusing on three main aspects, which is, as you mentioned, creation, preservation, and distribution. But let's start with distribution first. I think that is the first thing that comes to people's mind when it comes to estate planning. So intestacy is the condition of the estate of a person who dies without having enforced a valid will. So simply put, passing intestate means that an individual passes away without a will, and the distribution of their assets will be determined by probate court. So in the context of Singapore, how would one's asset be distributed if there is no will involved?
Right. Intestacy can be quite complicated. So without a will, the estate will be distributed according to the intestacy law and under the Singapore Intestate Succession Act. In other words, if you don't have a will, the court will apply their own rules to distribute your estate. And these distribution rules are fixed for everyone without a will. So regardless of the family profile, the mix, the amount of money, it's the same rules apply for everyone. There are 9 rules of hierarchy in terms of who should inherit your estate. So let me give an example of a married person without children. Let's just call them Mr. and Mrs. X. In the event Mr. X passes away, half of his estate will go to Mrs. X, his wife, and the remaining half will go to his parents, Mr. X's parents. If Mr. X's parents are no longer around, okay, then in that case, the full estate will go straight to the spouse, Mrs. X. Okay, so it is fairly straightforward. But let's say Mr. and Mrs. X have their own set of children, all right? So according to the rules of intestacy, the distribution will be totally different. Okay, so in this case, when Mr. X passes on, his estate will no longer be divided between the wife and the parents. Instead, his estate will now be shared between the wife and his children. The parents will not receive anything. So for a married couple with children, the couple's parents will be excluded in the distribution process if there's no will. This might not be what they want, so it's always best to write a will to avoid these undesirable consequences.
Right. So even from your short example, I can see how there could be some conflict, in terms of distribution as compared to what the person might want. So, for example, you mentioned that in the event that Mr. X passes away, half the money will go to the spouse, but half will go to his parents. So it really depends on the relationship between all of them and whether that's really what he wants.
Yeah.
So in that, sorry.
Yeah, and all right, just to be clear, what I've just described applies only to non-Muslims. Okay, because for Muslims, the rules of estate distributions are different. It's governed by the Islamic law, and they have their own sets of distribution considerations.
Right. So that's very interesting to know. Okay, so how does a will come into play then?
Maybe let me describe what's a will. Simply, a will is basically a legal document specifying how you want the estate to be distributed upon death. So, in the earlier example, right, Mr. and Mrs. X, you can specify that a sum of money goes to the parents and the rest goes to the spouse and children in whatever allocation you think is best. You can also include other beneficiaries other than the spouse or children or parents. You can include the siblings, the nieces, the nephews, the friends, and even giving to charities. So the will actually allows you to put down who you want them to inherit the money. So with a will, you have control over a few things. How much you like to give, what assets to give, who you like to give to, and when it should be distributed. In addition, you can also specify who should be the guardian to look after your young children should the couple passes away. Sometimes the preferred guardian may not be the parents. You may want certain siblings or a close friend to be a guardian, simply because of similar parenting styles and the common values that you share.
Right.
In a will, you can also specify who should be the trustees. Sometimes the surviving spouse may not be the best person to hold the money, because we hear of a lot of cases where money was quickly squandered due to poor financial management, losing the money really meant for their livelihood. So there are much more I can talk about on why you should write a will, but these are the key ones.
Right. Thanks for sharing, Eddie. So let's say a person is okay with interstate distribution of their estate. So should they still make a will in that case?
Okay. Yes, this is a very common questions people do ask. My answer would be a yes and a no. Well, if the estate is relatively small, okay, and the people that should be inheriting is straightforward. So, example, singles wanting to give the money, the estate, to either the parents or siblings, then I think it might be okay. However, the distribution process under intestacy is usually longer and requires more administrative work, and therefore it means longer time in the distribution process. All right. As I mentioned earlier, the will has a lot of advantages. Okay, it allows you to specify the choice of your guardians, the trustees, executors, and that might be important consideration for you. A will can also help to avoid certain undesirable distribution complexities, because sometimes when it comes to distribution, it get a little bit more complicated than what we imagine it to be. So one example is this thing called the common disaster. In the event of a common disaster, which basically means that both die at the same time, okay, like in a car accident, the question is how should the estate, the husband and wife estate, be distributed to their parents. So in this case, that we have the couple and then their parents. So there are 6 people in the picture. All right, there's no children. In this case of common disaster, should it be that those set of parents will share the estate equally? Okay, or should it be that parents will receive the estate of their own children? So meaning Mr. X parents will receive Mr. X money, Mrs. X parents will receive the wife's money, right? Unfortunately, the two scenarios will not apply. So let me give an example. Let's say Mr. X has $1 million and Mrs. X also has $1 million. So in a common disaster where we don't know who died first, the older spouse is deemed to die first. All right. So I'm not sure it's a good or bad thing. Okay. Let's assume that Mr. X is older, so he is deemed to die first. Since there's no will, out of his $1 million estate, $500,000 will go to his parents, right? And the other half will go to the wife. Okay, but the wife also died because she is younger and then she's deemed to die later. Okay, but she will have inherited $500,000 from her husband. Together with her 1 million assets, the 1.5 million will now go to the parents. So can you see that Mr. X parents now has $500,000, but Mrs. X parents have $1.5 million, I'm sure Mr. X parents will not be happy. You will find that it's unfair. So if you want to avoid this undesirable complexity or consequences, it's always better to write a will.
That's a great point you raised, Eddie. I mean, some people, they might think that they are okay in their state distribution. But like you mentioned, if common disaster happens, it might be something that it's a blind spot to them. So it's really great that you pointed that out. So Eddie, does a will cover all assets that one owns?
Unfortunately, the will is not the one and for all documents to cover all your assets to be distributed. Some assets cannot be distributed via the will. CPF monies cannot be distributed through the will. You will need to write a CPF nominations to distribute your CPF monies. Other assets that are not covered by wills are joint bank accounts, properties in joint tenancies, nominated insurance policies, and shares transferred in the shareholders' agreement.
Thanks for sharing, Eddie. So you make, it's really a very important point for everyone to know that doing a will will not encompass anything like what Eddie you mentioned. It's not a be all end all. And even after doing a will, it's important to take a look at, for example, your CPF nominations or your the nominees of your insurance policies to make sure that it's aligned.
That's right.
Okay, so let's say somebody wants to write a will. As you know, there's quite a few online will writing services that are either very low cost or even completely free in some cases. So what is Providend's take on this? And is it recommended that people use these services?
Increasingly, there are more and more online wills and DIY wills whereby it makes it very simple for you to have a will done. At Providend, we try to avoid it because from our experience, we find that most people need guidance in drafting their will, and they want to have a person to clarify how their will should be written. It could be who should be the trustees and guidance, and what are the considerations. Most people need some form of assurance when it comes to writing a will because they just want to make sure that all the blind spots are looked at, there's no loophole. Online wills might have some limitations too in terms of the level of customizations to your needs, which may not be apparent unless you are very proficient and very good in will writing. Another potential concern is that for online or DIY wills not done by law firms or lawyers, the probate registry is likely to request for another document called the affidavit of due execution. This document is required to be filed, okay? And the purpose of this document is to testify that that deceased will, the online DIY will, was properly executed. Because it's done by DIY, the court is just being careful that everything is in order. So it's always better to seek professional advice in writing a will.
Right. So how do we typically advise our clients then with regards to doing up their will?
Typically, our clients engage us for comprehensive wealth planning, and will writing is a part of the recommendations. So in this will preparation process, the advisors will guide the clients on a few important considerations, such as the advisors will guide the clients with a framework to think about how they want to distribute their estate. We will review their financial positions to estimate the size of the estate, whether it's enough to be distributed. We provide guidance on how their estate could be structured to align with their distribution wishes. We also provide guidance in the choice of executors, the trustees, and guardians. So once the will preparation is completed, we will bring our clients to our network of law firms to execute the will.
Thanks for sharing, Eddie. The topic of distribution is huge. For our listeners, if you have any other questions, please reach out to your trusted advisor or Providend if you have any other questions on this. So let's move on to the topic of estate creation. So some individuals do not have sizable assets, maybe except for their home. So these people have an urgent need to create more assets for their loved ones should they prematurely leave this world. So Eddie, what instruments can be used to create an estate?
All right. Yes, you're right, Isaac. All investment instrument needs the element of time for it to grow. The only instrument that could increase the estate significantly and immediately is none other than this thing called insurance.
Right.
Hence, insurance is often used as a tool in estate creation, so that there will be enough to be passed on to the beneficiaries.
When death occurs, the probate process, as you mentioned earlier in the podcast, could take some time before the money is released and distributed to your loved ones. In the meantime, there are quite a few immediate costs, such as funeral costs,
Right.
business debt, or even taxes. So what are some of the ways that people can look into providing liquidity in the meantime?
Insurance is not just used in estate creation. Insurance could also be used to provide estate liquidity. In a typical probate distribution process, it may take 3 months or more, depend on complexity. If you have a nomination in your insurance policies, the insurance claims can be paid out much quicker, within a month for straightforward cases. But even if there's no nomination done on the insurance policies, the insurer has the discretion to pay up to $150,000 to the proper claimant without the need to provide any grant or probate or letter of administration. So who can be the proper claimant? Typically, the deceased spouse, the parents, the children, the siblings, or niece and nephews can be the proper claimant. Having estate liquidity, as you say, is a very important consideration in estate planning.
Yeah, that's very comforting to hear. I mean, especially during a time of, let's say, someone's passing, it's money is not something that we want to be worried about. So it's glad that you pointed out that, yes, even though the probate process may take some time, but there are still ways that you can get some liquidity to tide you through the 3 months or more probate process. Right, so now we have covered estate distribution and estate creation. Let's move on to estate preservation. Eddy, what is estate preservation?
Okay, estate preservation is simply ensuring that the size of the estate does not suffer any significant reduction due to leakages. The more we are able to preserve, the larger will be the inheritance for our beneficiaries. And that's something that we want to do.
So what are some examples of leakages?
The common suspects are a few. First, the medical expenses, especially for expensive medical treatment in the last days of a person's life, like cancer. Therefore, it's important to have sufficient healthcare insurance to reduce the cost of out-of-pocket medical expenses. Other things would be like home loans, business loans, income tax. There are two things that cannot be escaped: death and taxes. And lastly, guarantor. If one pledged as a guarantor to secure a loan, claims could be made on the estate of the guarantor. So it's common for business owners to put themselves as guarantor to secure a loan. In the event of death, guarantor's estate will likely be required to pay off the loan, meaning lesser for the beneficiaries.
So how can we minimize these leakages?
It could be getting sufficient insurance or simply avoiding situations that increase liabilities, such as pledging oneself as guarantor.
So in terms of leakages, I'll think of, let's say, a small business owner. So most small business owners, they would prefer to keep their family businesses within the family. How does estate preservation come into play in this situation?
Okay, estate planning for business owners can be even more complicated because firstly, the value of the business is intrinsically tied to the business owners, right? Unlike investments like having $1 million in your shares, the value is there even after death, but the $1 million of business value may drop when the business owner is no longer around. Okay, the business will suffer when the business owner is no longer around. They could lose their key customers, key employees may leave them, creditors may demand payments, etc., ultimately affecting the viability of the business and therefore the business value. So a key part in retaining business value is business continuity planning and succession planning or grooming the next leadership team to take over. But all this takes time. Meanwhile, the business owners might want to consider some strategies like getting a key man insurance on himself, so that if something happens to them, there's a sum of money that will tide the companies through, or structuring a buy-sell arrangements with key shareholders to buy over the value of the business at fair value in the event of death. So these are very high-level stuff that business owners can consider. So the key thing is business owner needs to pay more attention on estate planning because their business usually form the largest portion of their estate, and businesses may not be able to retain the value when the business owner passes on.
Right, Eddie, that's very interesting. Like you mentioned, if you own shares, the value is not really tied to you. Small businesses typically do not have a lot of staff, do not have many staff, and in some small businesses, the owner is so crucial in the way that the company operates. So that's actually a very good point that you raised up. So now that we have covered distribution, creation, and preservation, so let's talk about estate planning as a whole. Just to begin, after we have done our estate plan, so how often should we review our estate plan?
Well, generally, you don't have to review it very regularly. The guidance is basically to review once every few years, or where there are major life events, such as changes in marital status, changes in the beneficiaries, changes in how much you want to give to the beneficiaries, changes in key people that is written in the will, like the executors, the trustees, the guardians, because they are no longer suitable due to poor health, death, or bankruptcy. Or there's changes in assets identified in a will. Example, that if there's, let's say in a will, there is the big ticket items is no longer there. Okay, it's always good to review the estate plan.
When we are in that reviewing process, what are some important things that we should take note of?
Alright, estate planning is not just about writing the will and updating it. Some documents needs to be considered also along the way. Firstly, CPF nominations, make sure that it's written and it's updated. Nomination on certain insurance policies to create the estate liquidity I mentioned earlier. Lasting power of attorney, LPA, which is basically a legal document to appoint persons to make decisions on and act on your behalf in the event of mental incapacity. Fourth, the advanced care planning, or ACP, which is a process to plan for your future's medical and personal care arrangements. And lastly, advanced medical directive, AMD, which is a legal document specifying that you do not want extraordinary life-supporting treatment in the event of becoming terminally ill. Some of these documents needs time to process and to execute. For example, the advanced care planning and the advanced medical directives, which may be something that you may not be ready to do now. It's okay as long as it's part of your radar to review that in the future. So these are some of the things to consider as you review your estate plans.
Right, so for lasting power of attorney, advanced care planning, and advanced medical directive, we actually done an episode earlier. So it's season 2, episode 16, titled All You Need to Know About End of Life Planning. So to all our listeners who are curious about this, you can refer to that episode for more in-depth discussion. So that's all for this week's episode. Thank you so much, Eddie, for your time today.
Thank you, Isaac.
To all our listeners, I hope you enjoyed our episode on estate planning. If you like this episode, follow our podcast and follow us on social media for similar contents. As always, thank you for listening, and I'll see you in the next episode. All analysis, views or opinions from interviews, recommendations and other information broadcasted, podcasted or published herein are provided for general information purposes only. Information expressed does not take into account any specific situation, particular needs or objectives, and should not be construed as specific advice or a recommendation. Information has been obtained from sources that are deemed to be reliable, but their accuracy and completeness cannot be guaranteed. Always consult with a qualified investment, legal or tax professional before taking any action. Provident Limited does not accept any liability for any loss whatsoever arising from any use of the information broadcasted or published herein. All contents and information contained herein may not be copied or reproduced in whole or in part by any means without prior written consent of Provident Limited.